I officially begin the webinar, and I would like first of all to thank all the panelists and the attendees of this webinar. I would like to thank Fondazione Feltrinelli, who is our partner in organizing this webinar. And when I say we, what I mean is the Institute for European Policymaking, which is the institute. It's a new institute in in Bocconi University, and it was founded about 1.5 years ago. And its goal is to bring together academia and policymaking and help bridge the gap between academia and policymaking. And I think this webinar is a great occasion to do that because we have two distinguished speakers from international organizations and from policymaking, and we have academics that will be speaking and that will be also asking questions as I see them connected in the list of attendees. So before diving into the webinar, I will leave the floor to Francesco Grandi from Fondazione Feltrinelli. He's the person in charge of research and development in Fondazione Gian Giacomo Feltrinelli. So once again, thank you, and for a quick word of welcome.
Thank you. Good afternoon. To extend our gratitude to Pietro Galeoni and the Institute for European Policymaking for this joint endeavor. We hope this marks the beginning of fruitful collaborations. For the Gian Giacomo Feltrinelli Foundation, the theme we are addressing today is of strategic importance. A decade ago, when we established the Observatory on the Future of Work, our primary concern was that workers and businesses might struggle to navigate the technological revolution on their own. Our aim was to foster a dialogue among academic researchers, social partners, policymakers, and institutions on how to navigate this challenge to create a more inclusive labor market and promote economic growth in alignment with social justice. Today's initiatives is inspired by our collective research projects, publication on work in the age of algorithms, conducted together with Antonio Casilli and other researchers from across Europe in partnership with Groupama. Over these 10 years, the question we initially raised have gained significant public attention, and various measures have been discussed, such as the protection for platform workers. However, the core issues of governing the technological revolution for the collective good remains, in our point of view, critical. This is why gatherings like today are so important for us. And thank you again, and have a productive session together. Thank you.
Thank you, and I see that Pierre Cordier has been able to join us, and as Carla was saying before, so we are happy to have him from Groupama, who's been a partner of Fondazione Feltrinelli in focusing on this project of platform work in particular. And so without further ado, I'll leave the floor to him for a quick welcome, and then we proceed with the first speaker. Thank you, Pierre.
Thank you, Pietro. Hi, everybody. First of all, was it important for us as an insurance company to deal with that topic? As you know, AI, big data, platform economy has turned into a practical and overall marketing standard of the industrial transformation. So there are lots of dreams and gossips about it, and probably it creates a deep and strong incentive to quick and unanalyzed transformations, enhancing the appetite of top managers for being modern and up to date. In that environment, we think it is very important to reflect and understand what's going on. That is why we decided, since our main activity is managing risks, we have in the hard way learned that not being aware of what concepts we use, what consequences we have to face when we decide to turn towards certain forms of social organizations, we create risks that we cannot cope with afterwards. So as a risk manager, we decided just to help thinking about the framework in which we will have to operate in the forthcoming years. It's just a small, a tiny contribution, but it is also an illustration of what we mean when we talk about ESG. So thank you for being there. Hope you'll enjoy the presentations and think a lot.
Thank you, Pierre. And with this warm and hopeful invitation, with this warm direction by Pierre Cordier, we enter the first speech by Tobias Müllensiefen, and he is from the European Commission, the DG Employment, and in particular, he works in the unit on the future of work. And so who better than someone from the future of work unit of the European Commission to describe to us what steps the European Commission is taking into to address the main issues that affect platform workers. So as a quick word of introduction, then I promise only a couple more seconds, and then Tobias, the floor is yours. As we all know, in recent years we've seen a development of both platform work and algorithmic management, not only due to COVID, also before the stage has been set about 20 years ago, and with the rapid growth of data collection by platform and with the development of these new actors in the world of work that mediate between supply and demand of work, this new form of labor has developed, which has been called platform work. Most notably, we've seen riders, delivery workers on the streets. However, there is a much broader range of workers that have their tasks, their hiring decisions, their firing decisions, their pay decisions, so many aspects of their labor decided by not an individual, but an algorithm. And so this is what is frequently referred to as algorithmic management of work. And the speakers that we'll have today will, I'm sure, describe this in much more detail, but the European Union, has taken steps into to address this situation, this new we can call it, I don't want to call it a new labor market because it's not a new market, but it's a development of, so this new development of the labor market. And so we will find out from our speakers where we stand, what legislative steps are being taken, and what the future holds maybe. So we'll try to keep an eye on the future and what the next steps will be in this important field. So with that, and no further ado, I'll leave the floor to Tobias to explain what legislative steps the European Commission has taken. Thank you.
Yes, good afternoon to all of you from Brussels, and thanks a lot for the invitation and for the kind words of introduction. So yes, I mean, Pietro has already done a fantastic introduction. So indeed, there have been developments, policy developments in the EU on the working conditions and platform work. There has been earlier this year in spring a political agreement on a directive on this topic. It's not fully adopted yet because we were at the end of legislative cycles, so there are still some formalities to do with the new parliament to get it onto the law books and into the official journal, but these should be formalities. So we hope for an adoption of the directive by September, October. Maybe a short introduction what we understand by platform work. Of course, most people have heard about it, but it's always good to know to be sure that we're on the same page. What is essentially platform work is a triangular relationship. There are at least three parties involved. There can be more than that. Namely a platform. The most common examples are, of course, Uber, Deliveroo, Foodinho, and so on. But there are many others that are much less known that organize work at the request of a client. So there's always a worker and a client involved. There can be more parties involved because there are sometimes intermediaries that are between one of those parties. And what is typical about platform work, and which sets it apart from temporary agency work, is that jobs are broken down into small tasks. So people are not usually paid by the hour, they're usually paid by the task. And what is also a new phenomenon is that it's the important role of algorithms in managing the whole system, because there's not that many people working for the platforms. So the usual tasks of distributing work, of deciding how much a task will be paid, and so on, is often done by automated systems. Next slide, please. You can, there are different categorizations of platform work. I think one of the most common, and that is also understandable for most people, is that one that we divide between platform work that is done in a certain location, and that is the most visible part of it. Food delivery, ride hailing, cleaning, handiwork services, and so on. But then there's also a lot of platform work that is exclusively done online. It can be highly qualified or low qualified work. Click work is usually associated with rather low qualified work. And then there's things like software development, graphic design, and so on. Next slide, please. So to give you a bit of an idea of the size of the phenomenon, we did an estimation in 2021, and we estimated that around 28 million people were doing platform work in the EU, at least as a very occasional, at least very occasionally. I mean, I would say it's only a minority of people, of those 28 million, who do this as a main source of income. What is also telling is the distribution between online and on location, because contrary to our impression, 3/4 of platform work is actually done online. When we did a study on how many platforms there are, we identified more than 500. This number might have grown in the meantime. And what is also, despite the very strong diversity of platform work, on average, working conditions on platforms are rather poor. I mean, we found that 55% of people on platforms earn at less than the minimum wage. And also there's a lot of unpaid work, like waiting time or time spent looking for assignments. Next slide, please. Now, the directive turns around two main issues in platform work that we have identified. I mean, you cannot, look for other issues as well, but we basically concentrated on those two issues. The first is the issue of the employment status, because around 90%, so 9 in 10 platforms indicate that the people working for them are self-employed. And in many cases, this is correct and this is true. It's basically self-employed people looking for clients through these platforms. However, there is also an important share of those people which might be wrongly classified as self-employed because they're in reality in subordination, or platforms exercise a certain control and direction over those people. And this direction and control may be hidden because it's not really exercised by people, but rather through algorithms. So it's not so easy to detect this form of subordination when it's when it's done via algorithms. And we've seen proof of this misclassification in a very high number of court cases on this specific issue, on the issue of the employment status of platform workers. And very recently, we've identified more than, I mean, not us, but a researcher working for us has identified more than 700 court decisions in 12 member states only on the employment status of platform worker. And this, of course, leads to uncertainty on, what is really the employment status in the platform economy. The second challenge is what Pietro has already called algorithmic management. And what we mean by that is automated systems that monitor work performance or that take decisions. So monitoring of work performance, like the obvious thing in ride hailing and in delivery, is of course the geolocation functionality, but you can also monitor other things like the activity, the output, and so on. All of this can be monitored by machines. And the other element of algorithmic management is decisions that are taken and that affect workers, like which tasks do they get? How much are they paid for these tasks? Are they promoted? Are they punished for not living up to the expectations of the platform, and so on? And of course, all these systems have impacts on workers, on their earnings, on their privacy, on their working time, on their health and safety, and so on. So it's an important element for their working conditions. Nevertheless, there's relatively little in labor law to deal with these elements. So that is one why we have decided to include also this issue of algorithmic management into the proposal for the Platform Work Directive. Now, what is the directive about? It has the overall objective is, of course, to improve working conditions and also data protection. Then we have a sub as a kind of, I already hinted to the employment status issues and algorithmic management. So these are, I would say, the two main chapters of the directive. And then we have a third chapter on creating transparency in the platform work economy, because it was not easy when we started our research to see how many platforms are there, how many workers are there, and still we only have estimations. We don't have real statistics yet in this area. So that's why the third aspect of transparency is also an important one. Next slide, please. So what does the directive contain? Well, on the first aspect, on the employment status, there is a rebuttable presumption of employment relationship. I will go into the details in a minute. Secondly, on algorithmic management, we have established new rights for people subject to these technologies. And there are obligations for platforms to provide information on the number of people that are working through them, their terms and conditions, and some of their working conditions. Now, I already mentioned, this is, we have, the aim is to improve both working conditions and data protection. And this is the first directive. And this is, of course, interesting mostly for lawyers, but that combines those two legal basis from the EU treaty into a legal instrument. Now, on the presumption, what does it mean? So it means that if there is a platform and there's a worker working for the platform, and there are facts that indicate that there is control on direction, like, for example, the platform determines the price, or the platform gives precise instructions on how to perform the work, or the platform supervises very closely how the worker is carrying out his or her tasks. So if there are these facts, then the worker and the platform are presumed to be in an employment relationship. And if it comes to a legal proceeding, it means that it's the platform can still contest that, but the burden of proof will be on the platform. So the platform will have to prove that, in fact, this is not an employment relationship. This is a simple commercial relationship, as you would have it with a self-employed actor on the market. Now, of course, how the precise, this is a directive, it's not a regulation. So how precisely this is done will be left to member states, but the directive prescribes that the presumption must be effective and must be a procedural facilitation for the person concerned. Next slide, please. So on algorithmic management, I will now not go into detail on this, but you see already from the number of items that there are a lot of new elements that have often to do with data protection, sometimes not. But for example, just to give you a few examples, platforms will not be allowed to collect data from persons when they are not logged into the app. Because that is something we have seen before, but this will now be prohibited. Also, the person doing the platform work will have a right to portability of the data that they generate through their work. So they will be able to download those data and personally bring it to another platform or to use it for other purposes. Platforms will also have to provide human oversight over the systems to see how they impact working conditions, and the persons will have a right to review certain important decisions that automated systems have taken. So you see, it's a quite comprehensive set of rights that the directive will grant to platform workers to deal with the fact that they are managed not by a human manager, but by an automated system. I mentioned before that usually platform work is imagined as a triangular relationship, but there can be also other parties involved. What happens sometimes is that the platform uses subcontractors who then do the contract with the person. The directive doesn't give very precise directions on how this should be handled, because there can be very different situations. But what is clear is that the persons will have the same level of protection. So member states have to make sure that these people who do not maybe have the contract with the platform, but with an intermediary, will have the same level of protection. Now, where are we? I already mentioned this in the beginning. I mean, there are a lot of steps involved. What is important, as I said, is that the formal adoption by the Council will happen in the autumn. It will be published in the official journal, and then there will be a 2-year transposition period for member states to put all this into their national law. Yes, maybe next slide. And I will finish with this. Of course, we are not operating in a complete vacuum. Some member states have actually already taken some initiatives before the EU legislator got active. That's the case among, for example, of France, Italy, and Greece. I won't go into the details on this, but part of this was granting also additional rights to self-employed platform workers. like collective rights, the right to strike, the right to join a trade union, health and safety provisions, and so forth. This is, of course, a slightly different approach that you say, okay, we let people fight out their employment status in the courts, but in any case, we also want to give some rights to the self-employed, and we do a bit the same because the algorithmic management chapter in the Platform Work Directive is largely, to a large extent, also applicable to self-employed persons working on platforms. Now, the what went already in the direction of the directive is the riders law in Spain, which was already introduced a legal presumption of employment in the delivery sector, in a very specific sector of the platform economy. And then following our proposal, which was done at the end of 2021, we've already seen some member states anticipating the transposition by already doing their own legislation inspired by the Commission proposal, and that was Belgium, Portugal, Croatia, and Malta. And finally, but I'm sure Ana Rosa Pesole will speak more about this, is that the ILO has launched a standard setting exercise for the years 2025-26, but that, as I said, I will leave to Ana Rosa to say more about this. Yes, this brings me to the end of my presentation, and I'm afraid that I will not be able to stay with you because I have another commitment. But I'm sure that Ana Rosa, who knows the proposal very well, can also, and also the directive can also answer your questions if you have any on the directive. And yeah, I would have liked to stay longer, but I'm afraid I have to leave now very soon. But thanks a lot again for the invitation and for the occasion to present this.
Do you have 1 minute more, or do you have to run right now?
I have a few minutes if...
Just one quick question to get your personal and also the perspective of the Commission on, as you have said, the directive took several years in the making. And of course, there is a proposal by the Commission, and then it gets of course, it has to be agreed by the Parliament and the Council, and it undergoes some changes. And what I would like to ask you, do you think there were some particular outcomes in the original proposal by the Commission that you think were very important and that the European institutions will have to go back to in future legislation, or that national governments should focus on and should add to the implementation of the directive?
Yeah, I mean, maybe to say this, so in the legislative process, of course, a proposal always changes. And I think that the dynamics on the two main chapters have been very different. On the employment status chapters, it was very difficult to agree with the Parliament and between the Parliament and the Council, the member states, because they had very different ideas. You know, the Parliament wanted to have an even stronger presumption, whereas the member states were a bit heading into the opposite direction. In the original proposal, we had 5 criteria for, and if 2 out of the 5 criteria were fulfilled, the presumption would be triggered. And that was very difficult, proved very difficult to agree. So in the end, you know, there was a bit more leeway now for the member states to transpose this by speaking only about those facts indicating control and direction. That is which member states can then adapt to their national legislation. So some people might say this has been watered down. I would rather say now we shift the debate to the member states, and now they, you know, the discussion has to happen at national level, how to really implement this into their national law. On the algorithmic management chapter, there was an opposite dynamic, because the Parliament has very much strength in that chapter, and it was accepted by the member states. So that is also interesting to see, that we have a stronger chapter now on algorithmic management than we had at the outset. And of course, this now raises the general question. Of course, now we have rules for algorithmic management in the platform economy, but algorithmic management is also happening in other sectors of the economy, spreading. I mean, where we see it most strongly is in the logistics sectors, in warehouses, in retail, but it's spreading also into the health sector, in hospitals, or in financial sector, and so on. So that is, I think, a question now. Do we also need rules on that in the larger labor market? And the Commission has not yet made any proposals, and that will be a question now for the new incoming Commission if they want to propose something on that. This will be a political decision, of course. I cannot anticipate what will be happening, but it will be an interesting debate to follow.
Thank you. Thank you very much for your participation and for what you've told. And I think there's very useful information for debate. One aspect that is very relevant in the implementation was what you mentioned about transparency, because in Italy, for example, being an Italian university, allow me to make this quick note. There was a legislative decree implementing the transparency of the algorithm. However, the interpretation varies from government to government, and with the governmental change in Italy, there has been a dilution of that principle, because they interpreted that as only referring to algorithms that totally automate entirely automate the tasks of so workers being totally and entirely automated, and that makes a huge difference. And there has been also political contention. So I think that also is very practical as to how member countries implement. And it ties to one of the other elements that you mentioned, which is access to the algorithm by the representatives, which was one of the elements that you included in your presentation, and I think is very important. And with that, I think you offered several connections to the next speaker, because first of all, by mentioning the ILO report, but also by mentioning the 2021 study made by the European Commission. And I know in 2021 in the JRC, Anna Rosa was working there. So before actually being a colleague of mine and being my office next door, she was at the European Commission. So perhaps she even worked at that very study. She will tell us. But as of now, she's a researcher at the ILO, the International Labor Organization, of course. And I would like to ask her, first of all, after Tobias's very enlightening presentation on the European legislation towards platform work, what is the situation in the rest of the world? So how are countries outside of the European Union approaching this new development of the labor market, and what is the ILO doing? What work is it conducting on this issue? And also to you, what do you think are the future challenges that policymakers should begin to think about when tasked with these challenging issues? Thank you, of course, for being here.
Thanks, Pietro. Well, I take advantage to say hi to Tobias before he leaves, because I know that he's leaving soon. And it was a pleasure to see you again. And as for I mean, like, I can put different hats when we're talking about the platform economy. I was in the Commission before, then passages to the Ministry of Labor in Italy, now at the ILO, but I'm not doing research because now I'm in the policy unit. So actually we are dealing with the process of standard setting that Tobias was referring towards the end of his presentation. So what is the situation at the global level? At the moment, the situation is the following. In October 2022, there has been a meeting of experts. I'm not going to have slides, sorry about that, but hopefully, it's going to be easy to follow in any case. There was a meeting of experts on decent work in the platform economy. And following this meeting of experts in the follow economy, the ILO governing body, which basically means like the government together with the worker association and the employer association, decided to place in the agenda of the 113th ILC convention a standard setting item on decent work in the platform economy, which basically means that it's going to be June next year, the first discussion about a potential global instrument, asking first of all, which type of instrument that might go into the direction of trying to regulate and to assess which is the situation about platform decent work in the platform economy. So what are the steps that normally are followed in this procedure? Perhaps this will be useful to understand how it works. So the first thing that has been done, it has been a normative gap analysis, and the aim of the normative gap analysis is to understand which are the ILO convention that already covers platform workers and which are actually all the new items or all the new regulation or the new elements that are completely new either to the instrument or that are not applicable to platform workers. One of the clear examples is that, for example, we heard from the presentation before from Tobias that there are a lot of issues which are related to formal contract, working condition, definition of remuneration of working time, definition of type of employment status. So all of these, for example, partially, some, I don't want to go too much into the details, unless there is a specific question about this, but in general, what I can tell you is that there are many conventions that would apply to platform worker, but there are also many conventions that actually would exclude platform worker because they are not thought for types of temporary contracts or self-employed workers. Another item that, for example, is not included at all in any convention of the ILO is the references of algorithmic technologies. There is not any, at the moment, there is not any ILO convention that talks about algorithms or the use of specific technology in the workplace. So taking into account this funding, taking into account the requests coming from the governing body, there has been like the first step, perhaps this slide would have been to share, but okay, now it's too late, which is basically the preparation of what is called in the internal jargon of the ILO, or what is called the white report. The white report is basically a collection of the initiative, the policy and legislative initiative that have been already undertaken by member states on the topic of decent work in the platform economy. So at the moment, we are at the stage in which this report, which is called Law and Practice Report, has been published in January 2024, and it has been followed by a questionnaire. The questionnaire includes all the topics that actually have been raised, both into the expert meeting or in the consultation with countries or in the consultation, even simply like from the analysis of the normative gap analysis that the office did. And the questionnaire is addressed to governments of the member states. And the way it works is basically that the ILO office sends the questionnaire to the government asking their opinion on the specific items that compose the questionnaire. Just to give an idea, the questionnaire starts, the first question in the questionnaire is, do you think that there should be an instrument? So this is the very first question, which of course, most likely the answer will be yes, as this has been agreed in the governing body that there's going to be a discussion on this. Then the second question goes on which type of instrument would you think more suitable in order to regulate decent work in the platform economy. And then the choice is between like the two typical, okay, I'm not going to enter too much in detail again, but generally, the ILO could either issue recommendation or convention, where recommendation have a more sort of like less mandatory framework, while a convention, once it's ratified by the country, basically asks to the country to adapt the internal legislative normative framework to the indication given by the convention. And then he goes into the specific details of each of the chapter that mostly were presented by Tobias before. One of the differences is that, for example, in the questionnaire of the ILO, there's not any question about employment status, in the sense that the approach that the ILO is taking is slightly different from the approach that the Commission took, because while the Commission tried somehow to reorganize the labor protection and the access to social security, rechanneling this worker either into the status of employees or in the status of self-employed. What the ILO is asking is demandating this entirely to country. The only thing that they're asking is to define which is the scope of the digital economy, which is the scope of platform work. So to say that in different words, what is included and what is excluded by this type of definition. Then there are several questions that, of course, relate to those that are the fundamental principle in the ILO, which is collective bargaining, OSH, everything related to the access to labor protection and social security, formalization. And there is also a part that deals with algorithms and use of algorithms in the workplaces. Now, the next step, this questionnaire has been issued and it's been sent to governments. Governments have to reply to this, they should reply to this questionnaire, taking into account after having consulted basically the social parties. So they have to take into account also the position expressed by the employers or by the worker association. At the same time, the official worker association, so ITUC for the trade union side, for the worker side, and the association of the employers, IOE, from the employer side, they can also they are legitimate being part of being constituent of the ILO to answer, to the questionnaire. And what is happening at the end, and the questionnaire, the deadline to send the reply is the end of August. What is happening after is that the office, which basically means myself and my colleagues in this specific case, we are gonna gather all the answer, and what we're gonna do is try basically to analyze them and report, which are the indication that came from the government, the employers, and the worker on the specific topic. And this is going to produce what is called, again, in the jargon of the ILO, the yellow report, which is the analysis of the responses received and the proposed conclusion. This next step is perhaps I don't want to say the first concrete step, because even the questionnaire, of course, is a very concrete part of it, but it is the first production of a prototype of what it could be, an instrument that is going to be after discussed by the ILC. So basically, this is going to be like the basic, the ground documents that will be used in the first discussion at the ILC next year. And the ILC, for those who are not familiar on how the labor convention work, is sort of, just to give a representation, it is a sort of like parliamentary hearing where you have the government and the worker representative and the employer's representative that discuss each item in the draft instrument and try, to reach an agreement over each item. So this is going to be like the first. Then this procedure is going to be a double procedure, which basically means that after the first LC, there's going to be another report reporting the results of the LC, and then according to what country, workers, and employer have agreed, there's going to be like a second discussion in the ILC in June 2026. So as you see, the time frame is quite extended, which basically means that, meanwhile, there's going to be also a lot of work in updating, because one thing that, of course, we are seeing is that many countries at global level, they are starting like legislating, they're starting like legislating on different topics, and there are new legislation or new collective agreements that are actually emerging in different parts of the world, which reflects, of course, like the internal dynamic of the country, also the internal like tradition of the countries, and they cover like different aspects. Some they might be more focused on access to social protection and labor protection. Other are more like on development of specific tools to guarantee that the social dialogue could be used in order to mediate the different needs of workers and platforms. So this is like this is what we're saying, is that there is a variety of policy initiative that have been taken. I can give you some example if that could be of interest. Like, for example, if we look at OSH, there has been an extension of labor protection and social security with respect to occupational health and safety in the workplace. And what you have is that, for example, in the Republic of Korea, the OSH Health Act extended protection in order to cover passenger in the transportation and delivery platform workers. So basically what they have to do, they declare that in that case, platforms are responsible, to uptake measures in order to prevent accident, in order to protect the passengers of the transport system. If you go, for example, to Portugal, what you have is a completely different approach. In Portugal is the opposite. The legislation is such that the person who's responsible for observing all legal provisions related to occupational safety and health is the driver himself. So this is also interesting to look at, because what you see is that different countries are actually using sometimes similar tools, sometimes completely tools that goes in the opposite direction. So this is also another challenge. The other challenge is try to find which is the principle that actually allow each country to adapt this principle to their own legislation and to their own system. There was something else that you were wondering. It was about I guess you asked me about which are the future steps. Well, so this is what the ILO is doing. Then the future steps in general are related to legislation that we see in the country, and the fact that actually this phenomenon is going well beyond platform work. It's a phenomenon that's it's a type of mediation that actually is increasing, and you are finding this type of organization of work in different sector now of what was called the traditional economy. So which basically means that this type of analysis might perhaps be just the stepping stone for something that actually needs to be well expanded beyond the border of the platform economy. That would be for sure. I mean, the adoption of algorithms, there are several empirical contribution in the literature that shows that it's growing. In particularly, Tobias already mentioned was the logistic, but it's not only the logistic. There is high manufacturing, there is the healthcare sectors, there is also the use of these tools in the public sector. I mean, since we are in Italy, I mean, we shouldn't forget the use of the incident that happened with Regione Lazio, when they were actually using an algorithm in order to assign the position of professor, the working place for professor, and that was decided by an algorithms. And I mean, the court case eventually they established back, the old manual assignation of teachers. But that was one of the example of how this use of digital technologies needs to be not only controlled and regulated, but also understood, because that's the other stuff. One of the topic that I think there is a little bit of lack of attention is actually on the channel, and the connection between the provider of the technology and the role of the employers. Because, and this is important particularly for employers, I think, more than for workers. Well, for both, of course, but it's the employer that are underestimating this. And a clear example is the fact that, for example, the regulation that was introduced in Italy has been watered down because it was thought to be like a too much big burden for employers. Well, actually, on the opposite, that perhaps would have been a form of protection for employers, because one of the things that eventually will happen is that in the moment in which employers are going to buy ready, already ready in technologies, because this is what's going to happen. There are not many companies who actually have capacity to develop internal technology, or they have the capacity, to even bargain for having a specific tailored technology. They will buy ready in technology without understanding many of the action that the technology is determined themselves. Still, they will be the responsible in front of the worker, because they are the employers of the workers, and they will be the responsible in front of the worker of any misaction that it comes from technology. And there is, at the moment, there is no any some form of protection for the employers towards, the technological provider. And this is an issue that has been greatly underestimated, by the PAD, actually, that you should be very much attentive to it. And another aspect is that, for example, you see clearly that is missing in the Artificial Intelligence Act from the Commission. This part is completely missing when they talk about labor, when they talk about artificial intelligence and labor, well, most likely this is going to be one of the items. This is going to be one of the items that in dispute resolution will come eventually out. This is like a sort of like my negative prediction for the future. if you want to.
Okay, thank you. So Pierre Cordier had left us with a positive outlook. You leave us with maybe something to look out for, but thank you for laying out some of the crucial challenges. First of all, understanding the reality that that we're operating, and then the ILO having to deal with differences both across space, different countries approach the issue differently, and across time, because it takes a lot of time to put in to collect all this information and then to put into practice all the standards that that the ILO sets. And during that time, the reality changes. The reality of algorithms also in the workplace change. And I think that is offers a good connection to the next speaker, Tito Boeri, since as we were saying at the beginning, this is not a new labor market. This is a change in the way that supply and demand of labor interact in existing labor markets as well. And so this poses interesting questions for academia, for topics that academia has already focused on in the past. So we've talked about an imbalance of power and in the bargaining between employers and employees. We have mentioned representatives. So the issue of unionization. How do individuals who are technically employees but are classified as self-employed, they do not have access to collective bargaining, to many of the institutions of the labor market that we're used to think about when it comes to standard workplace. So traditional concepts have to be adapted to this changing environment. And so as a discussant, I would like to thank Tito Boeri, so not only a great labor scholar, but also the host, since he is the director of the department. So thank you for being here with us. And if you could share your insights on this.
Well, first of all, thank you so much for inviting me to this very interesting discussion. I think it's very timely, and it is very important to promote closer interactions between academia and the work that professional economists are doing at ILO and at European Commission at the institutional level in trying to somehow regulate this new work organization that is developing. The first thing I think is important to stress, and I think it was somewhat also mentioned by the previous speakers, is the fact that we are dealing with an extremely heterogeneous group of activities and tasks. So there is clearly a completely different nature of the demand, labor demand, as well as of labor supply, which is involved by platform work and by the development of the artificial intelligence. Let me focus first on the so-called platform work and in particular the so-called gig economy. Here, there is not only a different profile of the labor demand, but there are very relevant characteristics of the labor supply that differ across workers. I've been investigating this by looking specifically at the nature of self-employment. And well, it turns out that we have to simplify, two broad groups of workers involved. On the one hand, we have workers who really are in a way complementing earnings. So these are secondary jobs for these individuals, or temporary seasonal work for instance, students and other people who just want to complement or to increase their earnings, and they pursue as much flexibility as possible in their in their desire, in their aspiration in terms of work. So they are not so much interested in employment security. They are interested above all in getting as much flexibility as possible, as they want to combine this additional source of earnings with a primary activity, which could be studying or could be carrying out another job. On the other hand, we have also a group of people who do this activity as a main occupation, and that really have this as the only source of income to a large extent. Clearly, the two group of workers have completely different needs. This second group clearly has security concern, as well as clearly minimum level of earnings clearly to be concerned, because clearly the fact that their job can be there is an issue of a critical level of earnings of these individuals, and the minimum hours the organization of work can be such that they really do not receive relatively low earnings in general. So the regulation has to be very careful in not crowding out one group to protect the other group. For instance, in some cases, the Italian jurisprudence has been taking the stance that all gig work should be treated as dependent work. I think that this approach is quite dangerous, because indeed it would displace completely the first type of workers I was mentioning before, who are clearly not looking for a dependent employment position, but are not looking for hours, relatively rigid hours of work requirements. Well, somehow it would move in the direction of offering protection to the second type of workers. At the same time, looking only at the nature of a contract, so whether it should be dependent employment or self-employment, may not adequately protect the workers of the two types, who in a way need to be in a way supported in their earnings, the wage levels they could possibly achieve, and also the type of social protection they can have access to. So I think that broadly speaking, the approach that one has to follow in these cases is to provide minimum support and establish some minimum level of pay, implement the strict rules concerning also the access to social transfers, rights in terms of pensions coverage, in terms of maternity leave, and all of these type of things. There should be, this type of protection should be offered to the workers, clearly on a pro rata basis, depending clearly, as many of the schemes are contributory, clearly will be related to the amount of work that they provide. And this type of thing should be really imposed by law and should apply to all type of workers. It's not an easy task, because clearly one will have to establish minimum wages in this case, taking into account of the amount of hours that are required for a different type of task. But that's something which is feasible, and complement this regulation and perhaps add more strict rules based on collective bargaining. I think that's really essential. And you know, the fact that these workers are on a platform to some extent make it possible to organize this worker. I know this from experience also when I was working at the Italian Social Security, and the other thing that the fact that they are on platform makes it possible is that there can be full transparency about their labor services and the way their work is being organized. For instance, in that case, we were providing ourselves a platform for organizing temporary jobs in Italy, and you know, all of these things we were just matching labor supply and labor demand, and everything was registered on the Italian social security system, and therefore employers were forced to pay contribution to the workers, and we had somehow clearly a view about the level of the pay, and there were clearly also minimum level of pay that were applied in that context. So I think one should work very much in defining minimum levels of coverage in terms of social security, of pay, and also safety standards, and above these levels let bargaining to take place, and unavoidably this can only be bargaining taking place at a rather decentralized level, because the needs of the workers of the different platforms are different, and the nature of the work of a task to be carried out is extremely different. Clearly, we are not only talking about the riders, we are talking about a very heterogeneous set of tasks that is being involved. So I think a big effort should be made, and I believe that government as well as organizations like the ILO should provide support to bargaining of workers, to workers who are chosen as a representative of a workforce involved. They should be training in bargaining, because that's not an easy task, and often unions are not represented in this context. So worker representative being elected by the other workers can do this, but they need to have the skills to carry out this type of task. Another consideration relates to the algorithm management. I certainly think that algorithm management can, in a way, is not the clearly something that could work on without any supervision by personnel managers and by clearly human resource management in the firm. But still, I think that there are also a number of advantages in using algorithms in managing the workforce, but we should not take the word algorithms as a synonymous of something of a devil, but should be banned altogether. Algorithm may prevent discrimination, which can be based on taste and on other matters, could also be a way to achieve discrimination, of course, but to the extent that the algorithms are known, could be quite a powerful way also to fight against many hidden forms of discrimination that are today present at the workplace. Algorithms may also be extremely useful in supporting the job search of people. There have been a number of studies suggesting that algorithms have been very powerful in reducing the job matching, in improving job matching between job seekers and also firms looking to fill vacant positions. So I think we have to be very careful in discussing this issue rather than taking a priori a stance against algorithms. What I clearly agree is that we should not operate on a standalone basis, but should always be some human control. And this, I think, is also in the spirit of the European Commission directive. But I think we should be careful in taking a negative stance a priori against algorithms. And finally, a few words about artificial intelligence and the world of work, as I think this is also part of a discussion today. I think that we should not make the mistake of confusing the potential influence of artificial intelligence of the world of work as a synonymous of displacement of human work. As a matter of fact, there is a key difference between some tasks that can be carried out by the artificial intelligence and that can be complementary to human work, and other tasks that instead are substitutes. Right now, we only have a limited knowledge about the potential application of artificial intelligence, but it is already clear at this stage that a number of tasks can be fully substituted by the artificial intelligence. Other tasks instead will be enhanced by the use of artificial intelligence. And other tasks, again, will not be affected at all by artificial intelligence or only in an indirect way. So it's very important to get a full map. I know that been several attempts in the academic work, but also international organizations like the OECD or the IMF have been trying to list all of this type of occupation and task and provide a catalog of those. Clearly, there are big issues here involved in terms of providing security to the workers involved by and who are currently carrying out those tasks that are at high risk of being replaced by artificial intelligence, and at the same time working on upgrading the work of those who instead operate in fields and occupations where instead complementarity between artificial intelligence and human work can be pursued and could actually at the end of the day enhance the quality also of a human work. And that again is a complicated thing to be done, especially because the artificial intelligence is being spreading at a speed that is unprecedented, and there are many new occupations and there are many new applications of artificial intelligence that we still are potential, and we see innovation almost every day on this. So here is again something very, very, very difficult. I think all countries should adopt, coverage and think about having stronger, protection against labor market risk at these times. And so I'm in a way concerned about countries that have relatively low social security coverage and unemployment coverage, and that are experiencing strong development of the application of artificial intelligence. One thing that is somewhat reassuring is the fact that developing nations, if we believe in the taxonomy that was devised by the IMF, are countries that are relatively less affected by development of artificial intelligence, and the share of jobs that are at the risk of being displaced by artificial intelligence is relatively low. As these countries are those that have clearly an underdeveloped social security system, you know, but that is somewhat reassuring, while the big changes are bound to occur in developed countries, where instead some unemployment benefit system is operating, although clearly maybe not having the type of coverage that would be needed at this juncture. And I would stop here.
Thank you, Tito. And I agree with you. The point is exactly trying to foresee where things are going with no a priori judgment. It's actually looking at there's no demonization. It's looking at how the algorithm is impacting workers and trying to, as Tobias was saying in the commission, and as Ana Rosa was also explaining, trying to provide, as you then correctly framed, the rights necessary to make it so that the power imbalance, you know, what quoting the Harvard professor Shoshana Zuboff, is the epistemic inequality that is caused by this proliferation of technology and algorithm. You know, this the making sure that this new frontier of technological change in the world of work isn't all sucking up the surplus from the workers, but allowing for a more balanced distribution without a priori or without canceling anything, because there is no doubt that artificial intelligence and algorithms are here to stay. So there is.
May I say just something on this, Pietro? Just to because I think it's actually
I would just say that those who want to sign up for questions, if you can raise your hand or write a question in the Q&A while Ana Rosa.
Yeah, I know it's just a very clarification, because I think that the teams, like, you know, when we're talking about the topic of algorithms management and algorithms and transparency, it cannot be done like quickly. So just to make sure that some messages are not misunderstood, is the point is this one. So the approach of today in terms of policy, and also in terms of what it should be the way of regulating algorithm, if any, is what everybody calls transparency of the algorithm. You know, we need to know which are the parameters, we need to know they used. Okay, now I kind of like oppose this view personally. I'm not talking like ILO. Now I'm talking about, as a researcher, we've been working on this topic for many years, and the reason is only one. And particularly, this is not transparency. This is visibility most of the time, which basically means that you are part of some information about the process, and you believe you might have like a better understanding of which are the risk of discrimination, or which are the risk of biases, or which are the risk of, you know, of which type of working condition is on interact, but actually you have no influence at all on the process. There is no involvement, no influence at all of, you know, of like any other stakeholders. I'm not talking just about workers. I'm even talking about government, actually, to enter into the mechanism and influences in order to protect the social value. Now, what it is that I antagonize particularly is not the idea of the algorithms. Algorithms have been successfully used in many occasions, in particularly for particularly dangerous occupation, in order to prevent incident, in order to prevent to improve harsh, in order to improve even like the efficiency of the plant, which in turn, if improve productivity, does improve also the quality of job of the worker itself. So this is not the issue. The problem is not the algorithms. The problem is the approach towards the regulation and the approach towards what it is that actually we call transparency. And to me, transparency has to go together with agency. If there is no agency, then there is a visibility process. If there is a visibility process, there is not a democratic approach. There is not a democratic possibility of a sustainable development. This is just to clarify, that I'm not at all a ludist. On the opposite, I've been studying technologies for many reasons. One being not being a ludist, just because I didn't want this, to be, perhaps I was misunderstood when I made the reference to the Muir case, which, by the way, I was corrected by someone in the audience. Yeah, I made a mistake. It was not the TAR of Lazio, it was the Muir indeed.
Thank you. Thank you, Anna Rosa. Is there anyone wishing to ask a question? We've had good attendance. We've had over 30. Now it just dropped below 30, so we've had quite a crowd. There have been some questions. I think two were about the presentation by the European Commission, and the first is asking why 2 years. It seems like a long period for the implementation, but I think as Anna Rosa afterwards explained, she was of course referring to the ILO, not to the European Union, but these things take time.
No, it's not. This is the legal prescription. Is the functioning of the European Union. It's just the legal framework. This is the way the European Union works. The legal framework of the European Union works. It's not up to anybody to decide the time. This is what. But the moment in which a directive has been approved by the Parliament, countries have 2 years to adopt it.
Perfect. Thank you. And so if there are no more questions, because Anna Rosa already answered one of them, as she herself said. Tito, Anna Rosa, any closing word that you would like to add before ending the webinar?
Well, no, simply that as I said before, I think it's very important to work on improving the knowledge of this issue, and by the relevant partners involved. I believe that there is not sufficient training often, even in those who are called to regulate this issue. And I think we should be relatively humble and be ready to really understand what and know what will be the future development, and trying to, because otherwise we run the risk of being always late in regulating these matters. And so I think that is something that we should envisage, and get the people who really know about what are the development of artificial intelligence to tell us in which direction we could be going. And clearly then we could try, and also rather than intervening ex post and being somewhat late, trying to direct the application of artificial intelligence in the most desirable direction.
Thank you. Anna Rosa?
I mean, like, the fact that regulation is late is actually the way regulation is born. I mean, regulation always come after the phenomenon. It's very rare. This is perhaps actually is the opposite. And that's why it's so difficult. It's the first case in which there is an attempt, a global attempt, to actually make a sort of like forward-looking regulation, which of course has from one side the constraint that it cannot be too strict, because in the moment in which, you try to regulate something that the boundaries are not very clear, then I mean, like, the risk is that it becomes updated. It needs to be updated after 2 years, so it's kind of like sort of like useless exercise. And then for the other thing is the point of in order to regulate technology, there is not a need of understanding how the technology works from a technocratic perspective. I mean, like, you don't need to be a computer scientist in order to regulate technology. You need to understand which are the aspects that actually impact, and you need to understand how to assure that there is a balance and democratic participation when you're taking the decision. So one of the big issues that has not been addressed, but is open for another workshop because it's a very, very long issue. Here's the treatment of data and the creation of public data infrastructure where to manage data, particularly when it comes to data of workers. Because at the moment, I mean, this is where actually, even in the future, when we were talking about before the importance of collective bargaining, the importance of fostering social dialogue, all of this, it would require necessary to understand the functioning of technology, at least partially, and to have control to some part of it, not just to control the consequences of it. If we want to have a proactive undertake, of this situation, but we leave the issue of about data public infrastructure for the future, I would say.
Thank you. Thank you both. And I don't think you could have left me with a better conclusion, because with these two aspects that you've focused on in these final statements about regulation and knowledge and their intersection, I think is exactly why we are here and why we're doing these webinars and these events. And as academia is at the forefront of trying to understand as much as possible and improving knowledge, and Bocconi is, of course, at the forefront of this effort. And as YEP, we try to bridge this knowledge with regulation, making sure that then more efficient dialogue, as Anaros also was saying, can happen, and so that the two don't go without interacting with each other. So at YEP, with social and civil society partners like Fondazione Feltrinelli and relevant stakeholders like Gruppo Ma, who's daily actively involved, as they said at the beginning, with ensuring better safety and health conditions for workers in the workplace. We can all together have better interactions, more interactions, so as to not necessarily anticipate what is the future, but at least try to keep the pace and ensure a better world of work as much as we can. So with this, I would like to thank you all for being here, both, of course, the speakers, the panelists, and those who have stayed until the very end of the webinar as attendees. And if you would like to stay up to date with our events, you can sign up to the Institute for European Policymakers newsletter, or the Fondazione Feltrinelli newsletter. And we hope to work again together soon on this issue and other important elements of the world of work. So thank you all. Francesco, would you like to say anything, or is this just a ciao from?
Thank you.
Thank you.
Thank you very much.
Bye.
Bye.
Thank you. Bye.
Bye bye.